Let's see if I can get this camera lighting. God, you know, I should have. Let me show you what this looks like. I hate this freaking thing. See, it's just a big disc. I don't know. I see other ones and they have like it's a light, but it's like makeup lights. It's just a circle, like a halo. It looks like a halo, and your phone can go in the middle of it. I don't know. I think this thing's just too bright, but yeah, gum. That's as low as it goes. Look at this. Look at that. Oh, I just need to buy another one. This is stupid. All right. Anyway, got a YSL update. I got several actually. People not taking pleas and trial updates. Let's take a gander and see what's happening. And one of them is God, is it? I think it's Demontre Kendrick. I think it's Kendrick. Maybe it's Stillwell. Hila Bumpus is representing him. A man. I think it's Stillwell. And to get a bond in order on his I don't know why he's just not settling. He has prison contraband charges, and the charges for the contraband are, if I'm not mistaken, I know it was like AirPods and some sort of multimedia device in a jail. Not dope, not sugar, not coffee, not even tobacco. Fucking AirPods. I can't even afford those. And he's getting them in jail? I'm not saying he shouldn't be charged with something, but this is ridiculous. I mean, he's already been found not guilty, or I swear it's Kendrick, but it may be Stillwell. You know, he had directed verdicts. Of course, he had the not we had directed verdicts, and then he had the not guilty. Well, the guilty of a felon possession of a firearm or whatever charge, but there's been several, and we'll try to go through them instead of doing separate videos. And try to comment on some of it. It's pretty funny. I've watched 2 of them, and some of the attorney excuses are quite humorous. So we'll get into that. All right, let me pull it up. Let's see, present. Let's see. Oh, okay. So yeah, all the co-defendants that are remaining rejected the state's offer. So now if they do a plea last minute, it's going to be based literally on the charge. They're not going to be able to plead it down and do like I don't know, like instead of a first-degree murder, I don't know, first-degree assault. That's not happening. So, and then you're going to be essentially doing an open plea, which is what Jeffrey Williams did. Anyway, it's essentially what you're doing at that point, and it's not good. So this is the last time they have a chance for negotiated plea, and even the negotiated pleas. I don't know, man. I've never seen prosecutors that think they can get so much for so little or from so little. But let's see what happens.
And I went ahead when I was addressing the rest of the remaining defendants and let
Mr. I'm not getting audio.
Is the last opportunity.
Well,
No, sorry, he was trying to say something.
Yeah, no, go ahead.
What is going on with this?
Okay, this will be the final opportunity today to enter a negotiated guilty plea, and that would be a plea that both sides have agreed to a recommendation, and if the court accepts the plea that sentences to something outside of that recommendation, Mr. McMillan would have a right to withdraw his guilty plea. After today, any plea that is tendered would be non-negotiated, meaning that if he decided to enter a guilty plea, any sentence that was statutorily authorized would be a possible sentence, and there wouldn't be any right to withdraw the plea simply because
you can't withdraw a plea.
I just want to make sure.
Yeah, she's just telling you that after today, it'll be what's on the charging document on the indictment is all you can plead to, and then if it's a 50-year sentence, 1 to 50, let's just say it's 1 year and a day, because in Georgia it has to be a year and a day for a felony, to 50 years. That woman right there, right here, she gets all the ability to dictate that.
Sure, and I know Mr. Dark, you've told that to Mr. McMillan already, but wanted to make sure that's on the record. All right, and I'll ask Mr. Abadi to please let me know what the state's offer was.
Defendant, where the state agreed, the state offer was essentially count one, conspiracy to commit RICO, and then count two, but the lesser included offense of murder, voluntary manslaughter, with a sentence of 20 years to serve, all of that time being parole eligible. It's my understanding that at this time, the defendant is not accepting that plea offer. So he'd be facing a mandatory minimum if convicted after trial.
Dude has such a weird staccato to his voice.
And do you understand that, Mr. McMullen? All right, and as I mentioned before, the fact that there was an acquittal of certain of your co-defendants does not mean that there would be an acquittal in a trial before a different jury with different prosecutors, different defendants, different defense attorneys. So it's a chance that you're taking, and you obviously have the right to proceed to trial. You also have the right to enter a non-negotiated guilty plea, although you can only enter a non-negotiated guilty plea to the charges that are in the indictment. I, as the judge, don't have any authority to reduce charges. So what I mean by that is, unless the state agreed to permit you to plead to voluntary manslaughter instead of murder, the only pleas I could accept would be to the murder and the conspiracy to violate RICO. So it's the prosecution's sort of venue, if you will, ability, and only theirs to lessen the charges. Okay, you understand that also? All right. Okay, Mr. Dark, is there anything you want to put on the record right now?
No, Your Honor.
Okay, and we discussed some timing already in your absence when I have the rest of the attorneys here. And what we all have settled on is the state gave an expected duration of trial of about 3 months. They think that's probably on the outside, but that's what we will anticipate at this point. We are going to have a status conference in this case on January 17th at 10 a.m. And we're going to discuss jury questionnaires and the voir dire process and things like that. And can you let me know, Mr. Dark, I know that some of you started the trial that already occurred, started voir dire, and some of you didn't. And I don't know what Mr. McMullen did. Was he a part of the past trial when it started?
Your Honor, Mr. McMullen tells me that he's in custody for the past 2 years with no counsel, so I don't believe that he would participate.
Okay, all right. And when did you become involved in the case, Mr. Dark?
I just was appointed, I cannot remember right offhand, but I know it was in the last 60 days, I think, Your Honor, 60 days or more.
Your injury was August.
August, yeah.
And that's a lot more than 60 days. That's more like 5 months.
August in the other case, and then in this case, it was in July 19th.
Okay.
Because
5
he has
months.
Some other things or something. But Your Honor, as I was saying.
Damn, and he actually made that argument?
Mhm.
I just got the discovery on.
So let me get this straight. Hang on a second. July to August, August, September, September to October, October to November, November. It's 5 damn months. And you haven't gotten discovery? Wow. How do they get licenses? I can't figure this out. It's like, oh, you passed our bar exam. It means you're definitely competent. Yet I pass it in another state and I can't get a license in Georgia. It's just bizarre. It's protectionism. Lawyers protect each other in their own state big time. They don't give a shit about anything else. They'll hide behind the whole, it's protect the system of justice and all that. No, it's not. It's about protecting how many lawyers are in the state. I can't believe this guy's even making the arguments. I sure as shit wouldn't. My ass would have already been to the prosecutor's office. Where's my discovery? Come on, let's go. We got all day. I need to know. Apparently, he hadn't done that either. And this is the 5th. I know why he didn't, because he knew the other trial wasn't going to. So he's focused on other work. I get it, but he has a duty to that client. Get the info. Just be going over it with him, because he might have. They might have had enough evidence in it to get a conviction, and they want to plea it out. That's gone.
This case on
Just dumb.
And I don't know what these other matters are.
And as I said to you at the last conference, you should have been able to get all of the discovery from you said there was no prior attorney? Okay, well, it was your responsibility when you were appointed to the case in July to reach out to the state and say, hi, I'm in the case now, I need the discovery. So I'm not going to delay the case past the trial that we're going to have of
So
all
that's
the
what he was
remaining
trying.
defendants. So you're just going to have to spend your holidays getting up to speed.
To be clear, I'm not asking for a delay. I'm just putting on the record the conditions under which I'm working. And I want to be effective for my client. That he should just be forced into trial just because
He is not happy or pleased.
The attorney was finally found for him after 2 years.
Okay, well, there was no trial for him within the last 2 years. If you were appointed in July, you've already had 5 months, and you'll have at least 2 more months to get ready. 7 months to get ready for a 2-count case is plenty of time.
Yeah.
So use your time wisely. Mr. Abadi, did you already provide Mr. Dark with the discovery? I know we discussed that on December 3rd.
Paige is looking a little haggard.
Everything, but I want to make sure I'm 100%.
Okay.
Yes.
All right.
Of course, I don't blame her.
So
I would be too.
the other dates.
Shit.
What's my place now? Lost my place. Okay. So we are planning to at least start from the jury questionnaires that were used in this prior version of the
She's
trial,
left-handed.
which should be filed. And any additions or deletions that you would like have to the court and opposing counsel by close of business on January 16th. And any and all motions in limine are due by close of business on January 15th.
That's a scheduling order.
The state is going to take a critical look at the discovery and potentially narrow what is going to be used at the trial. So you should have everything.
If y'all have watched my other videos on criminal trial process, they're at the end of their pretrial conferences. They're getting ready for trial. This is the scheduling order. I'm sure, well, they haven't had another one because the other cluster of a trial, the dumpster fire, the moving dumpster fire of the young thug case. This is the scheduling order. She's saying, hey, we're gonna have motions in limine. They're all gonna be in by this time. All of this stuff is gonna be taken care of so that I can get a jury struck on X.
Now, but everything may become a smaller subset of what you have now. And so they will get that to all of the defense attorneys by February 3rd so that you know what you don't have to worry about in terms of discovery. And we are looking at February 24th to begin the trial.
Yeah, this is a scheduling order. Yeah, they're ready.
And sometime between January 17th and February 24th, we may before that date get the jurors into, we're envisioning them coming in to answer the jury questionnaires on tablets. And so that we've got an electronic version of their answers and they're here. I mean, they may be here, they may be up in jury in the, I don't know if they'll be in the courtroom or not, but somewhere in the courthouse to answer the questionnaires, then get those to everybody and then have them back to do actual jury questioning and jury selection. So we'll talk about the ins and outs of all of that on our January 17th conference. All right. So do you have any questions for me, either of y'all, with regard to how the case is going to progress? All right. Okay. Then how about you?
How bright that was? That's on low. I cut the other light off
Mr.
and
McMillan, do you have any questions
it's
for the court?
washing me out. Damn it, I always buy the wrong
Are
equipment.
you going to want a few minutes to talk with your client after this, or did you have enough time beforehand?
I wanted to follow up because he had a question when we started.
All right. Okay. All right. We're going to go ahead and finish this, and then I'll
Yeah,
give you all some time
that's
to
over.
talk in the back.
Great.
I want to talk with you before you go back there, though, Mr. Dark, about the appropriate way to handle attorney conflicts.
Oh no. Oh no. No, no, no. 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 They have attorney conflicts. That's horrible. Damn, that's not good. Yeah, those suck. They really suck. I don't know if it's Caleb Bumpus that's the issue. Clearly, she's wanting to do it so that there's not an issue with the that's weird. The attorney representing whomever that kid, or I say kid, guy is. There must be some other conflict issues arising, and they don't want to have it bumped on an appeal because somebody screwed the pooch. So that's that. I don't know what y'all think about it. Any questions, please leave them. I'll be happy to respond. Let's see. Shannon Stillwell heads home from jail. And that's like 36 minutes. Dang it. Well, let's do Yak Gotti. Yeah, let's do this one.
Yes, sir. Now, do you also understand that because the sentence will also include provisions of probation, that you will have to comply?
183.
The state of judicial efficiency, I'll all remember.
There we go. There's
All right,
Max.
And Your Honor, I do believe that I need to sign some indictments in preparation of the plea. Do we have those in court?
So he's going to
Yes.
go ahead and take a plea and plead out and get out of these. Yeah, that's what it looks like.
Good morning, Mr. Jackson.
As you stand before me today, you are here on 3 indictments. Indictment 22 SC 181814, Indictment 22 SC 185532, Indictment 23 SC 188183. My understanding in consultation with the state and your attorney is that we have a global resolution to all 3 cases. Is that correct?
That is correct, Your Honor.
All right, you're going to be entering a plea of guilty to certain charges in these 3 indictments. So if you will, we raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? So help you God.
Yes, ma'am.
I need for you to tell me your name and spell it, please.
Shannon Jackson.
My name.
SHANNON JACKSON.
Okay, put your hand down. Now, Mr.
I've
Jackson,
actually
the
had
state
clients do
has a
that.
series of questions
State
to
your
ask
name,
you.
my
If you
name.
can, answer yes or no. If you need an explanation before giving an answer, let the court know and we will provide you with an explanation. If you need to speak to your attorney before giving an answer, let the court know and we will give you an opportunity to speak to your attorney. Do you understand?
Yes, ma'am.
All right, thank you. The state may proceed.
Thank you, Your Honor. Mr. Jackson, at this time, are you under the influence of any alcohol, drugs, or medicine that would negatively impact your ability to understand the case proceedings?
No, sir.
And how old are you?
32.
What's the farthest level of education that you've gone?
Ninth.
Can you read, write, understand the English language?
Yes, sir.
And you're a little soft
These are
spoken.
all
Do you mind speaking
normal.
up a little bit for Madam Court Reporter? All right, now, do you understand?
What I don't get is, at least in Alabama, I don't know why a prosecutor's reading this. I really don't, because normally the judge would be the one reading this and doing a plea colloquy. I guess it doesn't matter as long as it's on the record. It's just kind of bizarre. But now he's been in a while. His hair has gone from that rust-colored, and you can see the regular hair. I'm so jealous of him. He got to be in his 30s. He got a full head of hair. Man, going old sucks, man. Look at old Max. He's more like me. He just got tired of it, though, and said, screw it, I'm shaving it. That's what I should do. Just shave it off.
Understand that you were charged in case number 22 SC 181814 with possession of a Schedule 5 controlled substance, possession of a firearm during commission of felony, possession of a firearm by convicted felon.
Yes, sir.
You understand the maximum possible punishment on the possession of a Schedule 5 is up to 3 years in confinement.
Yes, sir.
You understand the maximum possible punishment on possession of a firearm during commission of a felony is up to 5 years.
That's going to be the coding.
Yes, sir.
You understand the maximum possible punishment on possession of a firearm by convicted felon is up to 10 years in confinement.
Yes, sir.
Now, you're also charged in resolving today case number 22 SC 185542, in which you were charging count 1 with serious injury by vehicle, count 2 entering auto with intent to commit a felony, count 3 theft by taking, count 4 failure to maintain insurance. Do you understand that as to count 1, the serious injury by vehicle, you could be sentenced up to 10 years in confinement?
Yes, sir.
Do you understand that for the entering auto, the maximum possible punishment for
Just so you know, theft by taking, why is it said that way? Because in Georgia, you've got theft by receiving, theft by taking, theft by conversion. You have common law criminal statutes. Not all states have that. Like a conversion would be, I borrow your lawnmower. You said I could borrow it. I borrow it. Let's never bring it back. You know, and then I sell it. Now I've converted the proceeds. So that's a theft by conversion. So that's just a FYI.
which you could be sentenced is up to 5 years in confinement.
Yes, sir.
And you understand for the theft by taking, based upon what the amount alleged in the indictment, that being greater than $5,000, less than $25,000, the maximum possible punishment for that offense could be up to 10 years in confinement.
Yes, sir.
And you understand that for the failure to maintain insurance is a misdemeanor punishable by up to 12 months in confinement.
Yes, sir.
Now, as to case number 23 SC 188183, you were charged in counts 1 and 2 with participation in criminal street gang activity, count 3, possession of methamphetamine with intent to distribute, and counts 4 through 8 with possession of prohibited items by
Another gang charge?
For those counts 1 and 2, the gang activity, you could be sentenced up to 20 years in confinement.
Yes, sir.
Wow.
You understand for the possession of methamphetamine with intent to distribute, you could be sentenced up to 30 years in confinement.
Yes, sir.
And you understand the maximum possible punishment for each of those possession of prohibited items by inmate is up to 5 years in confinement.
Yes, sir.
Now, do you understand that you have the right to plead either guilty or not guilty to any and all of these offenses? And if you pled not guilty, you would have the right to a jury trial in which the state would have to prove your guilt beyond a reasonable doubt.
Yes, sir.
Now, as your attorney, going over with you this form that I'm holding, plea of guilty, acknowledgement, waiver of rights.
Yes, sir. I remember.
As you have an opportunity to review this form, go over this form in its entirety, and do you understand this form?
Yes, sir.
Now, Mr. Shar, are you waiving any potential defects in this indictment on behalf of your client as well as formal reading of the indictment?
So wait, both.
And Mr. Jackson, do you need any more time with Mr. Shar?
Waiving the reading of the
No,
indictment.
sir.
Now, in relation to this particular case, I believe you've been arrested on all of these offenses. Do you understand that if you enter this plea, that this also can be used in the future? It's what we call recidivist punishment, which means that if you got in trouble down the road, a court could look and see these convictions and therefore go ahead and sentence you to something greater than it normally would. Do you understand that?
Yes, sir.
You also understand that could be what we call collateral consequences to this plea. What I mean by that
Which
is that this
strikes
can have a
rule?
negative
Habitual
impact
felony
on, say, your
offender.
ability to vote, your ability to have gainful employment, things of that nature.
Yes, sir.
Mr. Jackson, are you a United States citizen?
Yes, sir.
And you understand this is a negotiated plea of guilty,
Yes,
which means that your attorney and I, in the state, have come to a global resolution. We're going to go ahead and propose that to the court, and the court can choose to accept or reject that. However, if the court chooses to reject it, it could sentence you to something greater than what is negotiated. Do you understand that?
Yes, sir.
Now, do you also understand that if you were under probation or parole, that this can have a negative impact under probation or parole status. And to be clear, this would not have a negative impact on the offense for which you just were sentenced, as all of these offenses occurred prior to entering this plea. Do you understand?
Yes, sir.
Now, do you also understand that because the sentence will also include provisions of probation, that you will have to comply with all of those terms of probation, which also include not possessing a firearm?
Yes, sir.
You also understand that possession of a firearm, aside from a probation violation, also would act as a new offense as you are convicted of felony.
Yes, sir.
Now, do you also understand that there can be, do you understand that you're waiving any and all offenses, including any mental health offenses, by entering into this plea of guilty?
Yes, sir.
Now, do you understand? I'm going to read off a list of rights here. At the end, I'm going to ask if you understand you're waiving all of those rights, okay?
Right.
Do you understand that by entering this plea, you're waiving the right to a trial by jury, right to remain silent and not incriminate yourself, right to confront witnesses called to testify against you, right to assistance of counsel hired by you, or to court-appointed counsel if you cannot afford an attorney at a trial of your case, right to the presumption of innocence, right to testify on your own behalf and to present other evidence, right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
I understand.
Now, has anyone forced you, threatened you, or promised you anything to get you into entering into this guilty plea?
No, sir.
Now, your attorney has worked out certain cases in which, and certain counts in which you're entering a plea of no contest, as well as Alfred v. North Carolina, okay?
Yes, sir.
So I'm going to go over each of these indictments specifically. Do you understand Alfred v. North Carolina is a situation in which you're not admitting that you are in fact guilty? However, you do recognize that it's possible a jury could convict you, and therefore you believe this is in your best interest to go ahead and enter into that plea. Do you understand that?
I understand.
All right, so we're going to begin with case number
That gets you
23
past the
SC
fact-based
188183.
admission.
You understand you entering a plea of no contest as to the participation from most recent counts, which is 1 and 2.
Or the actual
You understand you also
admission.
entering a plea of Alfred v. North Carolina in counts 3 through 8, which is the possession of methamphetamine with intent to distribute and possession of prohibited ice.
Yes, sir.
Now, do you understand as to case number 22 SC 181814, your attorney has requested and states not objecting to an Alfred plea as to the count 2, possession of a firearm by commission of felony, and count 3, possession of a firearm by convicted felony.
Yes, sir.
And then that your plea will be a plea of guilty as to counts 1, 2, 3, and 4 on the 22 SC 185532, that being serious injury by vehicle, entering auto with intent to commit theft. I apologize, you don't have to by taking failure to maintain insurance.
Yes, sir.
Now, Mr. Sharp, understanding that you negotiated these with other attorneys and sort of standing in place, that very accurately summarized the counts, which are the no contest as well as the offer. Yes, sir. Right. Understanding all of that, how do you wish to enter your plea?
Good.
And that be guilty as to on the 22 SC of serious injury by vehicle, the entering auto with commit.
Hereby
with intent to
judge
felony,
guilty.
by taking in failure to maintain insurance. Is that
Knowingly,
good? As to the 22 SC 181814, which is the possession of a controlled substance, possession of a firearm during commission of a felony, and possession of a firearm by convicted felon, as to counts 2 and 3. Is that under Alfred v. North Carolina?
Yes.
And then count 1, the possession of a Schedule 5 controlled substance, is that guilty?
Yes.
And then as to 23 SC 188183, counts 1 and 2, the participation in criminal street gang, what is your verdict, or what is your plea?
No contest.
And the counts 3, possession of methamphetamine with intent to distribute, and the counts 4 through 8, the possession of prohibited items by an inmate. What is your plea?
Guilty on the F.
And is that plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand you have only a limited right to appeal this guilty plea conviction?
Yes, sir.
And do you understand that for the felonies, you would have up to 4 years from today's date is to file what we call a habeas corpus, and that's if you want to challenge the constitutionality of this plea.
Yes, sir.
And do you understand that there is one misdemeanor on here, which is the failure to maintain insurance? Do you understand that you'll have up to 12 months from today's date to also file that habeas?
Yes, sir.
Your Honor, I'm going to go ahead over what the factual basis is at this time for each plea, if it pleases the court. Judge, I will begin with the serious injury by vehicle case, which is the 22 SC 185532. Had this case proceeded to trial, the evidence would show that on June 7th of 2021, law enforcement responded to a motor vehicle accident on I-85 at Metropolitan Parkway, that location being inside of Fulton County. Judge, it was determined that this defendant was the at-fault driver in a motor vehicle collision that did result in the victim sustaining a fractured arm. Judge, there was a bystander that attempted to render assistance. Mr. Jackson then did leave from the scene in that bystander's vehicle without permission, that vehicle being greater than $5,000 but less than $20,000 in value. Judge, the defendant also did not have valid insurance at the time of the motor vehicle collision nor the departure from the scene. Judge, as to case number 22 SC 181814, had the case proceeded to trial, the state would show that on October 27th of 2020, law enforcement with Atlanta Police Department responded to an address on Judy Lane, which is located inside of Fulton County. They responded to that location because the defendant was parked inside of a driveway where he did not reside. Upon approach, law enforcement observed what appeared to be a prescription bottle. Judge, a canine came around and possibly tested, possibly alerted as to contraband inside the vehicle. The defendant was a convicted felon at the time. Law enforcement was able to locate a loaded firearm inside of that vehicle. Judge, in addition to locating promethazine, which was the Schedule 5 controlled substance. And Judge, finally, as to case number 23 SC 188183, while the defendant was at the Rice Street Jail located inside of Fulton County on March 29th of 2023, to case number 23 SC 188183, while the defendant was at the Rice Street Jail located inside of Fulton, the Schedule 5 controlled substance. And Judge, finally, as to inside of that vehicle, Judge, in addition to locating promethazine, which was the Schedule 5 controlled substance.
Promethazine? Really? Promethazine. You can look that up. It's PROMETHAZINE. It's called Phenergan. It is an technically it's an antihistamine. Believe it or not, it's now in most cough syrup that's prescribed. They, God forbid, don't want to give codeine, which actually stop your cough. This shit doesn't work at all, but it does work for nausea. It's a little caustic. They used to give it in IVs with an IV. it's real bad on the veins, so they don't even give that. So you'll get Zofran. I mean, this is a very, it's an antihistamine. It's scheduled, but it's low. It's low. I mean, it's this. Wow, I can't believe they charged him with promethazine. Holy shit! I bet you if you go in your cabinet right now, if your kid has cough syrup, it's going to say it'll say like promethazine DM, dextromethorphan with promethazine, Phenergan. It's Phenergan. Yeah.
And Judge, finally, as to
Every time I think this can get stupider, case gets more stupid. Like, it's just, I don't, I've never understood, even when I was in law enforcement, why cops want to just pile charges. What's the point? What's the point?
number 23 SC 188183, while the defendant was at the Rice Street Jail located inside of Fulton County on March 29th of 2023, law enforcement conducted a search inside of his cell. A judge that was a shared cell, and located inside of that cell included a cell phone. The pills that tested positive for methamphetamine, just the quantity would be consistent with the intent to distribute, as well as a chain, which is often used in either self-defense or to be the initial aggressor, primary aggressor, depending upon what day it is at Rice Street. And judge, possession of AirPods and an iPhone as well. Judge,
AirPods and an iPhone.
The negotiated recommendation is on case number 22 SC 185532. That's the serious injury by vehicle. Judge, the state's recommendation on.
All right, so it wasn't Kendrick. It's in the other one coming up. It's this dude. Stillwell just walked. How do you? I have heard of some weird stuff to get into jail, and it's usually in your Louis Vuitton prison suitcase or via your Louis Vuitton prison purse. But AirPods and an iPhone? Man, somebody brought that into him from as a guard. I mean, seriously, who brings? I can't even afford them.
Count one is 10 years to serve 3 years. However, that 3 years is commuted to time served. Count two, the entering auto with intent to commit a felony, is 5 years probated to run consecutive to count one. Count three, that by taking, is 5 years probation to run concurrent with count one. And count four, that failure to maintain insurance, is 12 months confinement commuted to time served. Judge, as to case 22 SC 181814, possession of a controlled substance, that judge recommendation is 3 years commuted to time served. As to count two, that would have to run consecutive to count three. So count three would be 10 years probation, and count two would be 5 years probation to run consecutive, for a total of 15 years probation.
All right.
I believe my understanding of the recommendation was that was going to be 10. The count two was going to be 10 to serve 3, commuted to time served, balance on probation, as opposed to 10 years probation.
I'll refer to you as you were the one actively involved in negotiations on this one, Mr. Chuck.
Okay, so if you just go over those again for the record, for count, for 22 SC 181814. Count one.
Is possession of a controlled substance, that would be 3 years, commuted to time served. Count two would be 10 to do 3, commuted to.
You can't do that if you're going to count three, because count two, possession of a firearm during commission of a felony, is a mandatory consecutive. So you would have to have count three, the possession of a firearm at some period of time, just statute minimum of 1.
Okay, so I don't have it in front of me. I think what I meant to say is count three. Count three would be 10 to do 3, commuted to time served, balance probated. And count two would be 5 years probation consecutive. Correct. The difference, Your Honor, is him essentially receiving a sentence of 12 years probation versus 15 years probation. The intent is it would be 12 years probation because he's already served those 3 years.
Yeah.
All right, so let's get clear.
That's a good
Count
argument.
3,
Good.
10 to serve 3, commuted to time served, balance on probation. Count 2, 5 years probation, consecutive to count 3.
Yes, sir.
And count 1, 3 years to serve, commuted to time served.
Correct.
Yes, Your Honor.
You may continue.
And as to case number 23 SC 188183, as to counts 1 through 8, they all would be a concurrent 5 years to serve 2 years, the 2 years commuted upon time served.
Damn, that's a lot
Judge,
of
there are
charges.
specific conditions that would go with these cases. Specifically, Judge, there was a negotiated from the trial division for a banishment from Metro Atlanta area as a condition of the sentence. He has to maintain.
I still don't know how that's legal. Banished from a jurisdiction. I mean, you could agree to it, but it's not legal to banish someone. That's like a bill of attainder. I remember, I think it was 92, I think. It was 92. I remember Guns N' Roses was supposed to play in Atlanta, and Axl Rose had a ban from Atlanta. And so they weren't able to play. They played in 2016, so obviously it didn't last, but I've heard of it. I've had clients that want to do it, but I've never had a judge in Alabama agree to do that, even as a condition of the as a plea. They don't like it. I've never had one that liked it, because you're restricting movement. Just sit there and go, well, you can come back. You can't come back except for XYZ. Well, there's too many potentialities to catch them up. I mean, you're just setting them up for failure. So I don't know. Max knows what he's doing.
In gainful employment while on probation. There be no contact or communication, either directly or indirectly, with any named co-defendant in the case number 22 SC 183572. There's be no contact or communication directly or indirectly with any persons associated or affiliated with a criminal street.
It's funny. Max Sharp does what I do. I'll rock as I'm standing there. I can't sit still. It's funny to watch somebody else do it.
Okay. And there's be no possession of a firearm on his person in any vehicle in which he occupies or any residence. Quite frankly, just no possession of a firearm, given he would be a convicted felon. Judge, I also understand, and Mr. Sharp had personally got concerns about being able to travel through the Atlanta airport. There would be no objection to an exception for the Atlanta airport. Judge, this is the only case that was assigned to my unit, and I believe it actually was initially with the high-profile unit, was the gang case. And so, Judge, I do want to clarify for future cases why I am consenting to a no contest on counts 1 and 2, as it's not something I typically do, as this court's aware. Judge, the reasons for that is taking into account the working relationship I've had with Mr. Sharp over the years, who reached out to me along with Ms. Bumpus to try to resolve this case. Just understanding that there is multiple cases here, so I did not want to run into a situation where Mr. Jackson, who's had some incidents, unfortunately, at the jail, was remaining in jail while we litigated whether or not we were going to be dealing with a no contest on this case. And that is because also in this particular case, the typical negatives of a no contest plea for the prosecution are not present, specifically because he is already a C recidivist. This is irrelevant, frankly, whether or not we will be able to have future pre-convictions in the future.
This prosecutor is actually good. He knows what the hell he's doing. Yeah.
Judge, understanding as well that the negotiated terms of a larger sentence include provisions of no criminal street gang activity, as well as the negotiation of banishment. Judge, I believe that is a fair trade-off in taking into consideration the banishment provision. And Judge, from a factual basis as to this particular case, Judge, we are running into a situation as proceeded to trial that this was in fact a shared cell. Judge, it's been in the past occasions where other individuals' contraband can in fact be found in other individual cells, as well as the fact that there was a shared cell, so there's other individuals who would have access. And Judge, in this particular case, I have not been made aware of any cellular dump in this particular.
It's 2025 almost. What the hell is this dumbass doing still wearing a freaking mask? Dude, go home. If you're that damn scared, go home. Damn.
Had a cellular dump been done in this case, I have provided with that.
Man, I was in the middle of that shit going into jails to see people. One of the few that would do it. Because I'm not doing it on video. That's just stupid. I mean, video court sucks as it is. Much less having a... No, I ain't doing it on video. Because when it's on video, you don't have any security with a client. If anybody overhears it, oh well, it's over. They'll use it. Yeah. This is stupid. I don't know if my mouse is showing up. This black dude right here, sheriff deputy. This moron, or bailiff, whatever, on the left. Dipshit.
And if there's possession or control or intent over the narcotics or objects inside that cell, we probably would be in a different situation. But I'm not going to hold Mr. Jackson at Rice Street or ask him to be held at Rice Street while we did a cellular dump in order to ascertain that we have a resolution that appears to be amicable with all parties. So just for future no contest cases, I want to be able to distinguish Mr. Jackson from other defendants that maybe argue were similarly situated.
All right, thank you. So will you go over the special conditions again so I make sure I have them correct?
Yes, sir. The special conditions would include banishment from the metro Atlanta area with exceptions for the Atlanta airport. Judge, that would also include that he has to maintain gainful employment while on probation. There is to be no contact or communication directly or indirectly with any named co-defendant in the 22 SC 183572 indictment. There is to be no contact or communication, either directly or indirectly, with any persons associated with a criminal street gang, as well as a no possession of a firearm. I do understand it may take a little while for him to be able to sort out the interstate compact, Judge. So there's going to be a sort of grace period, at least from the state, in relation to him being in Fulton County until he's able to go ahead and work that particulars out with probation for the interstate compact.
Because another jurisdiction has to accept his as a probation.
Correct.
Anything else?
Nothing from the state at this time.
All right. Anything from
Go
defense?
to Augusta.
Your Honor, I would just like you to know that Mr. Jackson is 32 years of age. His father is present here in court.
You can't ban him from a state. That's not going to happen. No appeals court's going to keep that. It's bad enough it's a city. It's just not going to happen. I don't care if he agrees to it or not. You can't do it. You don't have the authority to ban anyone from a state. So, you can say I'll leave and never come back if you drop a charge, but even that's borderline. When you're talking about a city, that's one thing, but a state? While he's waiting, because you have to, in order to transfer probation, you have to go through interstate compact. So let's say he wants to go to Florida. Well, you have to apply. Florida has to say yes. Georgia then has to say yes and apply and send it on over to Florida, and then they take it over, and it's a nightmare. So it may take him 6 months. It usually takes at least that.
Father works an honest job for an honest living. His wife is also present in court supporting him. He has 4 children. And so a lot of these past acts involve selfishness, immaturity. And I believe that Mr. Jackson, throughout this whole legal process, has come to realize how valuable life is and you only get one. And I think he wants to make everyone proud, all the supporters proud, and the people that have been here for him proud. So I know that he knows that he has people in his corner.
They
and
use
we're
his
hoping,
real name.
if Your Honor accepts his plea, we're hoping that this is something that we can all look back upon and say that this had a happy ending.
All right, so I have a couple of questions regarding the banishment. It's my understanding that he's from the metropolitan Atlanta area.
He is. Your Honor.
Okay.
He's lived here his entire life.
All right. So are there special circumstances under which he will be allowed to return during the period he's banished? Did the state negotiate?
Sure. So again, that was a negotiated term outside of the one. I understand there are going to be times in which this court would make exceptions, such as coming back for funerals or weddings. I understand this court traditionally does not do banishment outside of accepted negotiated terms. So to the extent this court is setting exceptions, I would
because it's illegal.
Your Honor, I anticipate that at some point in the future there'll be a need to return back to Atlanta. I'm not trying to violate any agreements that I have with the state. The way I thought, quite honestly, the way I envisioned this happening was if there was a specific need, Mr. Jackson would reach out to me, and then I would reach out to Mr. Sperry. I know that creates more work for all of us, but I thought that would probably.
All right, let's speed up.
532. The court is going to find that the defendant has entered a pleas that were willingly, knowingly, freely, and voluntarily given, and that there is a factual basis for each plea, be it no contest or an Alfred plea or just a regular guilty plea. All right. So we're going to start with.
In Georgia, some charges you cannot enter no contest on. You have to Alfred plea. I don't. It's been a while since I've done a criminal case in Alabama. We didn't really have a no contest, and we used to get around. We had Alfred pleas, but we didn't call them that. And yeah, you had prosecutors. Even when I was in Kentucky, our prosecutors, you had judges that would completely blow a case up if the guy got up there, and unless you were doing an Alfred plea where you could sit there and go, well, I'm not admitting fault, which is what a no contest is. So you're not admitting fault, but you agree that the facts of the case are XYZ. Yeah. So
22 SC 185.
Not every state's the same.
532. The negotiated and recommended sentence is on count 1. The defendant is to be sentenced to 10 years to serve 3 commuted to time served. Count 2, 5 years probated.
All right, so he just got a 10 split 3. So he's going to get 7 on probation, unless I misunderstood it or misheard it. The 3 years to serve is already time served. He gets credit.
To serve consecutive to count 1. Count 3.
Meaning that one is going to be separate, and it does not run on top of the other one. So he's not gotten credit on it, but he probably will because I think he's been in jail long enough.
Years probation to run concurrent to count 1. 12 months on count 4 commuted to time served. Count indictment 22 SC 181814. Count 3, 10 to serve 3 commuted to time served. Count 2, 5 years probation concurrent to count 3. Count 1, 3 years to serve commuted to time served. Indictment 23 SC 188183. On all 8 counts, 5 years to serve 2 commuted to time served, balance on probation to run concurrent with 22 SC 185532, count 1. And also in 22 SC 181814, the sentences are to run concurrent with count 1 in 22 SC 185532. During the time of your probation, you are to maintain gainful employment. You are to have no contact with any co-defendant in 22 SC 183572. I don't want to assume, is he not related to any of those co-defendants?
Sure.
All right, okay.
Yeah, because
So the people who used to be your friends or the ones that say you used to be associated with, you can't have any contact with them. That means you don't respond to emails, texts, smoke signals, shout outs, Instagram.
Smoke signals.
They're no longer people that you can have any contact with. Because if you have contact with them, you run the risk of being violated on your probation and you end up in the Georgia prison system. And from my understanding, that's not the place you want to be. I understand that you were assaulted while you were at the Fulton County Jail. And unfortunately, that's no place anybody wants to be either. So the best lesson for everyone here is to stay out of the criminal justice system. At one point, when I was a judge on the Fulton County Juvenile Court bench, 88% of the people in the Georgia prison system did not have a high school diploma. So what that tells you is the best way to stay out of prison is to get a high school diploma. So you indicated you dropped out in 9th grade. You need to go back and get a GED.
She was
so you can move forward
judge.
in life. If someone wants to give you an opportunity, you can step up and take it because you can check the box that I have a GED or a high school diploma. It is basically a weeding out process.
Yeah,
And they signed off on it.
I don't want to hear her.
You are to not to have any firearm in your possession because you're a convicted felon. And you're not to engage in any criminal street game activity. I assume that you know all of the co-defendants in 22 SC 183572. So you know the people that you're not to have any
That's
contact
with the
with.
YSL
I always make this
trial
an issue
that
with the
you
state
said.
because I don't want to assume that the defendant knows these individuals.
He does not know all the individuals, but he knows who they are from going through the case.
So I would suggest that the state provides him a list of all
That's the
these
one that's
individuals,
coming
their
up.
known names and their street names, and any other AKAs they have out there. So there's no misunderstanding. Okay. And your family members need to know that although you can have communication with them, they should not be carrying messages from any of these people that you're not to have any activity with. So did I miss anything?
Your Honor, just one thing, if we could put on the sentencing sheet, that all these sentences are to run concurrent with the sentence that Mr. Jackson has from 22 SC 183572.
Any objection from the state?
No objection.
Okay, so all the sentences from 22 SC 181814, 22 SC 185532, 23 SC 188183 are to run concurrent with 22 SC 183572. At this time, does probation need to come on record and say anything? All right. She can't hear you.
All right. That's good. I don't think we need to hear any from probation. Yeah, that's it. And yeah, Mr. Jackson goes home. He done. So that is how a negotiated plea works. You have just seen it. That's how you avoid a trial. That is what happens before trial. You got to do it before a certain point, or you don't get, like, you get what we had in the first video, which is a essentially you miss out on negotiated pleas. This is a negotiated plea. So yeah, I'm glad he's going home. Good for him. Hopefully he gets his life together. All right. Well, thanks. Hopefully we can get another update here. I just didn't want to make, it's already been longer than I wanted it to be by about 30 minutes. So, and I ran it on super high speed. So, if you would hit like, subscribe, and comment, I appreciate it. Thank y'all. We'll be seeing you soon.